Yeah, my mic's off. I forgot. My kids were mucking around. Hi. Hey. Mic off. Yeah, rookie mistake. I hope everybody is well and that you're not stressing yet. That would be a good thing. Low stress is always a good thing. Yeah, Joshua, give it time. No, we don't want stress in this unit. Stress is not a good thing. We just had a little bit of a break then because we've been gone since 6, so we had to give everybody a comfort stop. So we are this week looking at misrep. How are we all feeling about misrep? Are we feeling happy? Are we confused? We are looking at now, where are we going to go? We'll go with collaborative notes. Why don't we recap our readings for the week, just briefly, before we get on to looking at the animation for this week. Misrepresentation. What's the things that we need to think about?
So there's the 3 elements to misrepresentation.
Yes, there is more than 3, but let's start off with 3. Okay, so it has to be what?
A false statement about a past or a present fact.
Yeah, excellent, eh? Yes. Can I have some examples of where that might prove problematic? If I said to you, I will give you $100 if I am wearing a cream-coloured shirt today, that would be a statement of existing fact, yes? No problem at all. Where are the grey areas? The grey areas are what lecturers love. Tell me about the grey areas.
Well, I guess there's ones that you can't find out the answer to. So you're completely reliant on the person's information.
Yes. That is the kind of factual circumstance that can often lead to an opportunity to make a misrepresentation. And that was certainly the case in Gould and Vagalas, which was that High Court case that we have a look at in the text. I'm particularly thinking about things like is a statement of intention going to be an actionable misrepresentation? A false statement a statement of intention.
I wouldn't have thought so because it's in the future.
I am going to the supermarket next week. Yes, it's in the future. When will that be an actionable misrepresentation?
If you can't actually get to a supermarket and you know it.
Ooh. I'm glad you added in the last bit. So if will be actionable if the person doesn't actually have the intention. Excellent. Case?
Balfour?
Oh, sorry, someone jumped in there.
Balfour? Balfour and Clark? Balfour and Clark?
Balfour and Clark. Tell me about Balfour and Clark. And which case book are you reading from?
The 18.
Yes. Okay. Keep going.
I have to look at my notes.
Good. Curtis and Chemical Cleaning Company.
Sorry, what was that?
If it's not intentional, wasn't that Curtis and Chemical Cleaning Company?
Yeah, you've got to be thinking about whether or not the person had the actual intention that they're telling you that they have. Where's my
Mary?
Here it is.
Once upon a time, there was a girl called Mary.
So the case, the famous case that decided that intention could actually be actionable.
Redgrave versus Heard with the solicitor's house.
That was the solicitor case.
Mary's mum and dad.
If you look in your case book, it is the first case in your case book.
A self-taught country doctor.
Edgington.
Yes, that's it. Edgington. And in that case, very famously, the English Court of Appeal held that the state of a man's mind is what?
The same as his digestion or something like that.
I love it. The state of a man's mind is as much a fact as the state of his digestion. So if you say, I have a gastro-type stomach situation happening right now, and you didn't, yes, it's going to be a false statement of fact. If you say, I'm going to the shop next week, but was it Josh that yelled out, you find that you can't get there?
Yes.
Yeah. And you can't get there because a flash flood has destroyed all the roads. That's going to be as much a statement of fact as anything. Why? Because in stating your intention, you've actually represented that you have that intention. And if you don't have that intention, it's a false fact, isn't it? That's how the courts get around it in order to give somebody a remedy. That was a case where Edgington and Fitzmaurice was that case where there was an issue of debentures. Remember? A company issued some debentures for the purposes of alterations to buildings and also to purchase horses and vans. And in actual fact, they just paid down company debt with the money. So they said, we're going to take this money, we're going to use it for this purpose, but they actually didn't. And they knew that they weren't going to use it for that purpose when they made the statement. Yes? What's another problematic case here of opinion? The case that we had on opinion in the case book.
Bissett.
Yes, good. The sheep case. Sheep case. What was the opinion? What did they say?
Wasn't it about something that hadn't been farmed, so they couldn't claim that the land was unusable or something along those lines?
Yeah, they said, let me just get here. I'll copy my notes in here for you. Bissett and Wilkinson. If the property's worked with a good 6-horse team, it should carry 2,000 head of sheep. That was the opinion stated. Why wasn't it? Why wasn't it an actionable misrep?
Because no one had actually ran sheep yet, had they, on the property?
No. And
But everybody knew about it.
Good. Who was that, Josh? Both?
No.
Both?
No.
Who was it?
Daryl.
Daryl. Thank
Yeah.
you, Daryl. Thank you, Daryl. Okay. So both parties knew the vendor had not operated a sheep farm. So I call it the case where the blind was leading the blind, and everybody knew the blind was leading the blind. Okay? I guess that's not terribly politically correct anymore, is it? Better take that out. Okay? There was no misrep there because everybody knew it could only be an opinion, because he was just faffing off at the mouth. He'd never run sheep on that property. No one had, and everybody knew that was the case, yes? It will be actionable where the opinion conveys a fact that's false. So where you're in the position where you should know what you're saying is wrong and you still say it anyway, then it will be actionable. So in Smith and Landon House, where the the vendor said that he had a most desirable tenant when he knew that the tenant was bankrupt and was consistently late in paying rent, that opinion conveyed a fact that he had a reasonable basis to say this is a desirable tenant when he actually wasn't. Yes? So courts might get around it that way. What about puff? What
That
about
relates back to the whole Carhill smoke ball company thing, doesn't it?
Yeah. Puff, not usually actionable. Not usually actionable. What about, might be different under the ACL if a reasonable person might have been misled, and there's a few, actually there's a few Gold Coast property cases where that's succeeded. Not surprising. I'm a Gold Coastie, so I can say that. What about silence? What's the go with silence?
Isn't that only if there's a duty of disclosure?
That's one of the situations, yes. Not normally actionable, but there are those exceptions. One of those exceptions is where you have
Half-truths.
Yes. When you have made a half-truth. And in both of these situations, you can see there's an obligation. I wouldn't exactly call it a duty, actually, to disclose, because that comes more under your negligent. But in terms of half-truths, you've said something that's kind of true, but you've left out the really crucial bit that makes it actually false, then you're under an obligation to tell the whole truth. If you're going to go to any bother in saying anything in terms of pre-contractual negotiations, you need to make sure that everything you say is the truth, the whole truth, and nothing but the truth. Yes? If you bother saying something, it's got to be right. You can keep quiet, sure. But if you go to the bother of saying half a story, you got to tell the rest of the story.
I've got a question about that. With, say, agents and principals and stuff like that, you're talking about silence. So knowing, especially if you're going to real estate agents, knowing and withholding and not passing it on of a major issue, that's basically, we're talking about that there, aren't we?
Yes.
So, give you a perfect example of literal current times. I'm looking at buying a house to renovate, and with planning law and everything, you can't call council and understand what's got planning approval and everything on someone else's property. So how do you know if structures are clear and fine and legal? And you know the agent knows but won't tell.
Yes.
And that's misrepresentation, isn't it? Because it's really, obviously they can have disclosure forms and all that and play cover up, but...
Well, it's not misrepresentation unless they've gone to the bother of giving you a snippet of truth and then haven't told you the rest of it. And that's why you'll find that they usually go to the trouble of saying you've got to do all your property searches before you,
Yes.
before you cool off. That's why there are cooling off periods, so that you can do all of these kinds of requisite checking.
Isn't real estate treated slightly different because of the length of time?
And you're talking about the remedy of rescission, the rule in Seddon's case?
Yeah, I read in the book there yesterday, the day before, that because of the length of time of a real estate deal, you have plenty of time and not a snap judgment to go and investigate everything that's wrong with it.
Yes, and that's where the rule in Seddon's case comes in, and it's normally only for land contracts, and it's precisely because you do have that length of time to do all of your property searches. You can do your title searches, you can go and do your inspections. For me, it took me over a month to do all of my property searches on the place that I've just bought recently. And I've got all of the records from the body corporate. I went through those with a fine tooth comb. I had pest inspection, building inspection. I had all sorts of inspections. I've got all of the plans. That's the kind of length of checking that you have to go to in those deals. And yes, the rule in Seddon's case says that if it's a property deal and the matter has already settled, so the money's changed hands, title's changed hands, the deal is complete, then you can't rescind the contract any longer. Yep.
Just one side note, without trying to get off track, but it kind of is. Have you ever heard of title insurance?
Title insurance? I'm not a property lawyer, so
No. Just going over it, just because it's one of those things. When you buy a property and you pay like a sum of $500 roughly, it's a one-off payment that covers you for every sin that you don't know, because you can't find out planning legislation on any other home, or planning zoning if it's got a planning approval. So if you go and buy an old house, and most people do, if there's an extension or an add-on or a boundary fence or alignment, you're covered legally, because the fines are huge.
Oh,
Like you can get fined $200,000 and $25,000 a day while you're out of planning approval.
wow. Well,
So you can buy a house for $600, and at the end of the week you owe more in fines than
that would be unfortunate.
Which state are you in, Michael?
Say again?
Which state are you in?
I'm in WA.
Okay. In Queensland, there's not that figure amount.
No, I haven't been, and also in Queensland, there's a rule of thumb where the property legislation really only came into effect. The property legislation really only came into effect in most council areas in about 1974. So anything pre-74 is just, council doesn't even raise an issue with it.
Yes.
So, each state will vary. This is not property law, so let's move it on. Okay, statement later becomes untrue after you've made it, but before the contract has been concluded is your other exception there, when silence will become actionable. Okay, you might also, somebody mentioned this here, there is a duty of disclosure in terms of the relationship between the parties that does crop up here that you need to discuss. But now let's just make this really clear. This duty of disclosure that we mentioned here, don't confuse with the duty under negligence. In terms of this is specifically in relation to the type. This is in relation to the type of misrep being made. Yep. So, false statement of past or existing fact. Then we have some of those fiduciary relationships that says, okay, we need to disclose there. It has to be number 2. addressed to, has to be a false statement of fact addressed to who?
The innocent party or the representee.
Yes, the representee. Sorry, I've got people texting me like crazy and I am trying to put this on silent, but it's not working. Okay, addressed to the other party. When does it have to be made?
Before the time of contract.
Thank you, thank you. I had someone giving me a chat there. Sorry if I've missed the chats. Can't be in the future. Dairy and pig. Oh, okay. Complete statement becomes false. Yes, okay. At or before the time the contract was made. And the last point here?
Must be intended to induce the other party into entering the contract.
Beautiful. Thank you, thank you. Intended to and did induce the representee to make the contract. And then we have our three different types. Well, I will say here on that point, have a look at Gould and Vagalas. That's the High Court case that talks about inducement. Okay?
Is that also related to reliance?
Yes. Inducement and reliance. Inducement is the here. Intended to is what the representor intended. So they made the statement intending to get the other party to sign into the contract. Okay, so that's what the representor intended. And then the effect of that was that it did induce. Okay, and that's where you've got the reliance bit. So it was intended to, and it did induce the representee to make the contract.
So coming back to the property side of things, real estate agent says to, say, Michael, yes, you can put a duplex on this particular property, no hassles at all. Knowing that Michael was looking at trying to buy a block of land in order to have a multi-residential property built onto it. So the real estate agent knew that's what he wanted. So he made the statement in order for Michael to purchase the property.
Classic. Yep. Classic kind of situation. You're saying something that you think will reel them in. Yes? Now, the representee, so the person that's received the representation, who is usually the plaintiff, has to show that they were induced to enter into the contract. Now, how do they show that the statement was made intending to induce them into the contract? And in Gould and Vagalas, you had the situation where it was a property that was for sale, a tourist resort on South Mole Island, and obviously the person buying it wanted to know if the thing was profitable. So they made misrepresentations as to the takings. They made misrepresentations as to the percentage of room occupancy to make it sound like the resort was more profitable than it was. So that's the kind of thing that people will say to reel someone in and get them to sign on the line. Now, what they said is, how do you go about, because there was no issue there. And this is interesting. There was no issue. There had been a misrepresentation. It was a fraudulent misrepresentation. So the only way that the defenders could try and get off of this thing was to say, okay, sure, there was a fraudulent misrepresentation, but the representee can't show that they relied on all of this. Yes? And what the court did to make their life a little bit easier was they said, if it's clear that a representation is calculated to induce, you're tossing something out there in the hope that they'll pick up the crumbs, it's calculated to induce, to enter the contract. If the person actually, in fact, that should be, enters into the contract after you've made that kind of juicy statement, there's a fair inference of fact that they were induced. So that's all you really have to show. Okay. Then, once you've shown that that's a kind of statement that would tend to induce them to sign up, you've got this inference working for you. The other party then has to try and rebut that fair inference of fact by showing that you either had knowledge of the actual facts and therefore you couldn't have relied on misrepresentation, or you made it plain somehow that you were not going to rely on the representation. Okay? Doesn't have to be the sole inducement to contract. It's okay as long as it plays a part in inducing the person to contract. Alrighty. The only other thing that I wanted to go through with you, because we can cover off this this tutorial problem fairly quickly. What I did want to go through with you, because I think the text discussion of fraudulent misrepresentation is okay, but I'm not 100% comfortable with it. And I just wanted to make sure that we were all on the same page, okay? Now, let's just put that in there, fraudulent. Actually, no, I won't. Let me see where you're at, and we'll spend the last little bit of this unpacking the tutorial problem. Fraudulent misrepresentation. Tell me about fraudulent misrepresentation, because that's the one we don't really need to know about the other two for this evening because it's not relevant to the tube problem. But tell me about fraud for a minute.
Was that Lord Herschel?
It was. Yes.
And he talked about that it need to be, the misrepresentation is an untrue statement that is made knowingly, with no belief in its truth, or with no care whether the statement was true or not.
Yes. Yes. That's exactly it. What does it mean? Unpack it for me just for 1 minute. Unpack that. Someone else pick up and run with this. Okay. Lord Herschel in Darien Peak said that a misrepresentation will be fraudulent if it's made knowingly, without belief in its truth, or recklessly careless whether it's true or false. What do you have to show for fraud?
That the misrepresentation, that the person who made the misrepresentation made it knowingly, so it was something that they knew that they were doing, that they, when they were saying it, they had no truth in it. They knew there was no truth in what they were saying, and they didn't care whether or not the truth was there. So I knowingly tell you that the sheep is black, knowing that it's actually grey, but I don't care that it's grey because I'm telling you it's black.
Yes.
Kinda.
Yes, that's it. It's been implicit in everything you've said to me, so tick, tick, tick. What I want you to do is put your finger right in the middle of it. What test does the court use? Is it objective?
Subjective.
Ha! Subjective. So what do you have to prove?
You have to prove what happened.
And was acted upon.
You have to go, sorry, what was that?
Yeah,
And acted upon.
Being acted upon because it was what was going on
inside my head.
Yes.
Induced, but yeah.
It's a subjective test. And this is why it's so darn hard to prove fraud. Because I've had a lot of first years say to me, hang on a minute, and now I'll cut and paste. Careless, whether it's true or false. It's careless. If they're careless, it's fraud. But that's not the nub of it, okay? The point of this really is that they could care less.
So does this come back to like he said, she said?
Pretty much, unless you've got a smoking gun, some kind of magic bullet, a nasty email that proves their intent, it's really, really hard, because you'll see further down in Herschel's statement, what are you going to do to prevent it being fraud? You just have to show that there was, I honestly held this opinion. And that's what I actually meant at the time. If that's the case, you will not have fraud. Okay?
Just a question. What happens if the other party denies what you're saying? How can you prove fraud? So like if you say like, oh, this is what I believe, but then the other party says, no, this is what happens, then how are you meant to say what's fraud and what's not?
Unless there is a very, very good way that you can show, unless you have external circumstances that can only point to an intent to defraud, it's going to be really hard to show it. Okay? It's not easy. It is really not easy. To succeed, you have to show that the representor had no honest belief in the truth, and that is really hard. It's hard to prove a negative.
I was going to say, how do you do that?
Yeah, it's really difficult, and it's not, and this is why I say first years are often really, gung-ho. Oh, we have to find a remedy here. We have to get this person out of trouble. Surely this person is going to be doable for fraud. Fraud is not that easy to jump over, okay? Now, it doesn't mean that you're left with nothing, because it might be innocent misrep. But as you know, innocent misrep, what's the remedy for innocent misrep?
You can rescind.
Yes, but you can't get
damages.
Yes. So it might leave you without damages, but you should be able to get out of the contract as a base level, unless you can prove negligence. Okay. So I wanted to go through those points briefly. Now we can skip over. I'll stop sharing that, and we can skip over to. I like these little animations. Who's enjoying the animations? I think they're quite good. No one? Maybe it's just me. All right. Let's go.
How's business? You still make the best pasta in town, you know.
Hey, thanks a lot. You should come back into the restaurant soon. I'll have the chef make you something special.
You know, I'd really like that. But in any event, welcome to my shop. What can I help you with?
It's a bit embarrassing. I've been pretty foolish, I think.
You know, everything you tell me here is confidential.
Okay, you remember Maria?
The waitress in the restaurant. She was lovely.
Yeah, I thought so too. In fact, once she began working for me, I started to feel pretty strongly about Maria. I guess I started pursuing her. You know, romantically.
I understand. How did that go?
Not too well. She wasn't real interested at first, and I wasn't sure how hard to push. You know, being her boss and all. I didn't want to have to come see you about a sexual harassment claim.
That's very wise.
Anyways, eventually she seemed to come round. We went on a few dates, had a few laughs, maybe a couple of overnight stays. You get the picture?
Sure.
As things progressed, I was like a teenager all over again, daydreaming about her, distracted at work, trying to make little romantic gestures all the time. It was nice. She wasn't really doing the same in return, but some girls are like that. I thought things were going nicely.
Were they?
Well, there was this big incident. Maria came to see me and said she was in trouble. She used to date this slime called Ed. Ed was involved with drugs. And now the drug pushers were after Maria for 30 grand, which they said Ed had borrowed. If they didn't get it, they threatened to burn Maria's house down. Obviously, Maria didn't have that sort of money. She came to me for advice.
What advice did you give her?
Well, I told her I would lend her the 30 grand and that she should pay it to the men and then immediately afterwards go to the police.
That's extraordinarily generous.
Yeah, but I thought I was in love, and there was something kind of cool about coming to the rescue of a damsel in distress. You know, kind of like a gentleman.
Did you give her the money?
Loaned it to her. Yeah.
Do you think she will see it as a loan?
Oh, yeah. We signed a piece of paper saying so. I didn't really want to. I didn't really expect to ever see the money again. But she insisted that she wouldn't take charity and made me sign.
Did she take the loan money and pay the drug dealers?
That's where the whole story gets a bit crazy. Next thing I know, you see, she's driving around in a new car. She never brings it to work, but I've seen her around town in it. And I hear one of the other waitresses saying that she's just bought a new laptop computer and a new TV set and got pay TV connected. I'm not sure there were any drug dealers at all. I asked Maria about this, and she broke off our relationship saying I didn't trust her. Damn right I don't trust her now.
That's probably a fair call. What do you want to do?
What do you think? I want my money back. Can you help me?
I'll certainly do my best.
Okay. Immediate reactions. Sorry,
Sucker born every day.
that's someone's. Oh my feed. Oh, it's the ad here. It's the ad from YouTube. Okay, let's start sharing our screen again. Okay, let's do this. Now, poor old Rocco and Maria. Issue. Someone shout it out for me. Let's go, Pips. Powering through this.
Is Rocco entitled to a remedy of rescission and or damages as a result of Maria's misrepresentation? Maybe.
Good. I have someone chatting to me. Hold on. Yeah, she picked up my audio in the background. Did Maria fraudulently misrepresent herself? You could say, did Maria commit a fraudulent misrepresentation, perhaps? Okay, rules. What are the elements we've just gone through?
False statement.
Yeah. Of?
Drug dealers being after her and owing 30 grand to them.
We're just, we're in our rules section.
Of a present
Thanks, Michael.
fact?
Past or present fact. Made. Let's go through our elements, people. We're not at the analysis yet.
Must be the intention of inducing the other party to contract.
Yeah, that's number 4.
Oh.
Made at or before the time of contract.
At or yes. Okay, this one will be the Gould case. Here we need to be talking about Edgington and the other two. The other two aren't really normally too much of an issue. They may become an issue, but okay, let's get in here, people. How are we going to start this off? If it looks like a duck and it waddles like a duck and it quacks like a duck. Sorry, the people that were in my drop-in Zoom should be, that should immediately alert you to what we need to do here.
Show similarities to the other cases.
Okay, so we need to go on element 1. Are we going to go straight for here? I know what we could do. We need to show what kind of misrepresentation here. What did Maria say?
She was indebted by 30,000 to drug dealers or something along those lines.
She didn't want it to be a charity either.
Yeah, she wanted the money for
Her ex.
paying.
Yeah, pay for drug
Being in
dealers.
debt.
Yeah. Because why?
Her house was going to be burnt down.
Yes. So the purpose of the money was to
Save her house.
Yeah. Okay. Is that a statement of fact?
I would say yes.
Anyone else?
Yeah, I would have thought so too. It's like saying I'm going to go to the shops next week.
That's it. But you need to classify that, don't you?
Intention.
Because it's not like saying the sky, that's it. Thank you. It's not like saying the sky is blue. It's not that simple a fact, is it? It's saying I intend to use that money to pay off the drug lord.
Yeah.
It is a statement of intention. And this is where then you start going, it looks like a duck. In Edgington and Morris, what happened? We need to start pulling out those facts to show the marker that we know the facts of that case and why it's similar and why we're talking about it.
Well, the investor bought bonds for the purpose of refurbishing buildings or something along those lines. You know, they spent it on reducing debt.
Yes, thank you very much. Was that Daryl?
Yeah.
Thank you, thank you. That is it. Let me just copy and paste them. Sorry, not Edgington Fitzmaurice. Dairy and Pig. Well, we could use Edgington Fitzmaurice, but we'll use Dairy and Pig because that's straight from this area. All right. That's probably.
So I did have Edgington there because it was so similar with regards to the money not being stated in the prospectus for what it was actually used for. So it was a fact that was untrue.
Yeah, you can use Edgington and Fitzmaurice. I will put that in there as well. They are very similar cases. Hang on, where are we? Oh, look here, there.
So as long as you can actually pull out a similar fact and you can make a substantive argument, it wouldn't matter if you use one or the other.
No. There we go. 2. We might just pull that one back a bit. Sorry, I'm trying to put this. There we go. So, in Dairy and Pig, we have now the reason why I've gone to Dairy and Pig, I guess, you'd use them for slightly different. You'd use them for slightly different purposes. Okay. Let me just put this one down below. So, The state in Edgerton and Fitzmaurice, we have the company issuing debentures for alterations to buildings, purchases of horses and vans, but the money was actually used to pay down company debt. In that case, Lord Herschel said, the state of a man's mind is as much a fact as the state of his digestion. Okay, then you'd go back and you'd compare it to here. So a statement of intention can be an actionable misrepresentation. Yes? Here, similarly, we have Maria, who has represented that she will use the money to pay the drug lords. Now, what's the difference here? Is there any difference?
I think Derry and Pete just went more into the fraudulent side.
Yes, it did. So if the purpose that she stated was incorrect or false, then the statement will be an actionable misrepresentation. Yes? However, what are the issues here that we're going to show from Derry and Peak? Talk to me about Derry and Peak and the issues that it will show for us.
On their prospectus, they believed that they were going to get the steam engine, but they didn't get it from the Board of Trade. So basically, it wasn't their fault.
Yes.
They represented that as not their fault, whether it was true or not.
That's it. They said that they had an honest belief that the statement was true. So this gets back to our discussion that we had just before, doesn't it? Here, do we know whether Maria had a belief this statement was true? If she had an honest belief that she would pay the drug lord, Rocco has no remedy, yes? So, what are we going to do now? What facts can we pull out from what we were given that might show she had no belief that she was going to pay off a drug lord?
Running around in a new car, new computer, quitting the job. Didn't she quit or nick off when the fella confronted her with it?
She did when he confronted her. Yeah, she bought what else was it? Was it a laptop, cable?
Laptop and a TV and set top, pay TV.
Pay TV.
My biggest concern with all that, though, and maybe I'm looking outside of the box and maybe I shouldn't be, there's nothing in the actual story to say that that's what she used his money for.
Ha ha! Good. You're thinking like lawyers. However, is this all going to show intent?
Well, he'd have to actually try and find proof to prove that the money that she bought all that property with actually came from his pocket.
She might have just had a rich auntie might have passed away and she might have come into some other money. Yes?
The proof would be if the house is still there.
Or, you know what, you probably would need to, what would show that she had no intention to pay a drug lord when she made that statement? What would be the kind of time you want?
Contract for the car the day before the money came.
What would show that statement to be false?
Well, if Ed, her ex, was still being chased by the drug lord, then perhaps it was true. I don't know.
The kind of evidence that would conclusively show that she was telling porcupines would be if you could find from her previous friends, associates, any evidence of this ex called Ed or his drug involvement. Yes, because then you would be able to show that at the time she made the statement, she had no belief, no honest belief in its truth. Yes, because here, if she had that honest belief, it's not going to be fraud.
But does it come back also to the fact that the onus is on the innocent party? Like, he has to actually prove that, doesn't he? Not her?
Yes. So that's what I'm saying. If he had evidence that there was no drug lord, he'd be home and hosed.
And then it would be fraudulent.
And then it would be fraudulent. So what you do, and this sounds terrible, but it goes on all the time. I've done it for I've actually done it for a defamation case. We've had private eyes. We've engaged private eyes to go and surveil a target's property to see, it sounds terrible, but this stuff goes on, to see if in actual fact her story stacked up. So you could potentially start interviewing associates, people that knew her but weren't too friendly that might alert her to the fact. So assuming that you could find that there was no drug lord, then it would appear that Rocco could show that the statement was made knowingly that it was false. Or on the other phraseology of Lord Herschel, without belief in its truth. It was a lie. Short of that, it's going to be very difficult. Okay, fraud is a very serious conclusion.
Wouldn't it just be easier to get receipts from the stuff she purchased than to run around getting private investigators and searching for people that may or may not exist? Her ex could be called Ed and just she uses it and then you're dead in the water. Just, it seems so far-stretched. They were looking for drug lords and an ex called Ed who...
But couldn't the receipts don't actually say where the money came from, though?
Well, that's right.
No, it doesn't, exactly. But it tells you when she bought it. And if she bought it that day, she got the money, and it's kind of telling you something.
But, well, we are assuming that because he knew her and had a relationship with her for some time prior to this all happening, he knew that she didn't have the car before. He knew she didn't have the laptop or the TV or the cable or whatever beforehand. And it's only after that he's given her this money that she's suddenly bought all of this stuff.
Yeah.
So I think it's fairly safe to assume that she's bought it after he's given her the money. The only thing that you could possibly do, again, but this won't really, if you trace that back, right, if you got bank statements to show the money going into her account and then the money going out of her account to buy the car, to buy the TV and so on, does that still show that she had no belief in the truth of the statement, I'm going to pay a drug lord?
No, it doesn't. No.
She could claim she got a discount for paying a lot of it at once.
She could claim that Ed, somehow had the drug lords taken care of. And then all of a sudden her drug lord problem went away, but she's already, contracted with Rocco to loan this money, so she might as well spend it.
And at the end of the day, she did sign a piece of paper with him saying that she would pay him back. Not necessarily that he expected to see it back, but she did sign a piece of paper saying that she would give him the money back.
This is right. So can you see what I mean? You've got to think really carefully. Sorry to run over time a little bit. You've got to think really carefully about the kind of evidence that you can show to try and stack up for fraud. It's going to be quite a high bar to get over, because all that person has to basically allege is that they had an honest belief that there was this person, and you know, they had to pay them off, otherwise their house would burn down. And then the problem is that you have to show that that subjective intention is not right. Yes?
Maybe he shouldn't have confronted her and maybe had a conversation instead.
It's a quiet word. But, someone's saying something to me. The intention was that she had to go to the police. I don't know whether the condition was that she had to go to the police. He said that he suggested that she go to the police. But, if it was a condition, okay, let's think about that. If it was a condition that she had to go to the police, what does that do for us? How far along the track does that get us?
He'd still have to start investigating and try and prove whether or not she did or did not go to the police, and then they're not going to actually reveal police records to him anyway.
Well, the thing that yes, you're gonna be going. You're going to be doing a bit more fossicking about in the factual matrix. But I guess my point was, if you're starting going down that track, then what you are looking at is alleging a breach of condition, not a vitiating factor.
More of a breach of contract because they haven't met the main condition of the contract.
So if she fails to go to the police, she's breached the contract in my scenario. And therefore, we are then thrown back onto that whole ugly analysis of whether, it is actually a condition, or is it just a warranty or an innominate term? If it is, let's say, best case scenario, okay, she's breached the condition, sure, we can terminate, fine. That will get us into the same position as if we can get out of the contract otherwise. But can we get damages? And this is the thing here. Okay, so if we can't prove fraudulent misrepresentation, she's not going to get damages, is she? If on Michael's scenario, if she breached a condition, she might be able to get, Rocco might be able to get damages. But what's she done? She doesn't seem like she's got a spare 30 grand up her sleeve and she's spent all the money. So then what's happening?
Yeah, because can the courts make her pay it? I mean, if she doesn't have it, she doesn't have it.
That's it. Can't get blood out of a stone. Assets. Possibly, but I think she was a Pavo student, wasn't she? And she was working at his restaurant and then not working at his restaurant.
And once the car drove out of the car yard, there's 5 grand gone.
Yeah, tell me about that one. Garnish your wages. Potentially. But then you've spent $150,000 taking her to court for a 30 grand bill. Can you see how what seems such a simple, straightforward scenario is actually, once you start unpacking it, it's not quite as simple as you think? I have a decent IRAC that I will pop up for you on this. That probably makes a little bit more sense than our haphazard notes, but I'll put our notes up there anyway. Conclusion, it's probably
Rocco's stuffed.
Yeah.
Conclusion is stop knocking around with drug-addled females, I suppose.
Stop cracking on to girls at work. Probably not going to succeed in fraudulent misrep. Yes?
Would that be another problem there because he's the boss and she's the waitress?
Oh, yes.
No, but wasn't that brought up that he was actually concerned that he wasn't going to have a sexual harassment case?
Oh, yes. This problem has so much going on right now, but we'll probably leave it there for probably no success in fraudulent misrepresentation. What I do want you to think about, though, is a case next week. I think we have. Yes, we do. Yes, we do. We have duress, undue influence, and unconscionable conduct. And there's a case that we get to do next week called Louth and Dipros. Louth and Dipros. And it's quite similar to these kinds of, this factual scenario. So once you've read Louth and Dipros, come back and revisit this and see what you would argue, okay? Just take a little back step and see what you think. Questions?
Can you put up the notes that we made from the Zoom on Moodle 2, please?
Yes. The notes from tonight?
Yeah, the ones that we did in the, in the drop-in session from earlier.
No problemo. Any other questions?
Not unless you've got a few minutes, because if you can go back to sharing the notes that you had before, was it Lord Herschel that mentioned something about the state of the mind is the same as the man's digest, or whatever it is?
Yes.
A question on a current case that'll be going through, and the lady that with the axe in the 7-Eleven store, she believed that someone told her to do it. That's her state of mind. That would be an fact, because she believed.
Oh, Agent Morris? Yeah.
Yeah.
What was your scenario?
So the current court case at the moment, where the lady took an axe into a 7-Eleven store, I think it was Sydney or Melbourne or something like that, and hit 2 people with it. She honestly believed that she was told to do it in her mind. So would that have anything to do with this case, or would you be able to use part of that case for the 7-Eleven case, or am I just completely off topic and mentally unstable myself?
I haven't actually. I have 2 10-year-olds and a 13-year-old, and I don't watch the news for that reason.
Right. Neither do I. Between appointments, I listen to the ABC radio.
Oh, okay. So we have a. Sorry, people. If you want to leave, thank you for coming, and I'll put all the notes up. If you have any questions, just post them. Post them up on Facebook. Post them up on Moodle. You send me an email. We'll sort them out. Other than that, we will continue contemplating the weird case of the axe murderer. So go, explain to me. We have an axe murderer.
Yeah, so basically a lady took an axe into a 7-Eleven convenience store in Sydney, and she obviously hit a couple of people with the axe. She says that she woke up the next morning not knowing anything about it, and she was feeling a little bit groggy and only read about it in the news and realised that was her that had did it. But she also said that she had now a person in her head telling her that she had to do it.
Mm-hmm. So that, to me, that will be a criminal case, and because there is no issue of contract, this stream of case law won't be relevant to that matter. What will be relevant is whether she had an understanding or an intent to do the act that she did. So whether she had the capacity to know what her actions were. And in that kind of a circumstance, you will be looking at delusional states and whether the conduct was undertaken in a delusional state. Because it's criminal law and a completely different branch of law, you will have a whole stream of cases that govern that kind of conduct where the end result is injured parties as a result of a crime rather than the end result being a contract that someone is unhappy with.
Okay, cool.
So, yeah, unfortunately, we don't, it would make contract law a whole lot more exciting if we had axe murderers. My end of term exam paper last time I taught was a house that had been sold where a triple murder had been had occurred, and whether or not that had to be disclosed under the ACL, actually. So whether the silence of not disclosing that there'd been a triple murder was actionable under Section 18. It was an interesting little paper. I'll put it up for you if you're interested.
Yeah, it'd be good because as a real estate agent, my viewpoint would be that would be a disclosable or a relevant fact material to the sale. Because people might not buy a house if it has had someone either died or murdered or even ghosts.
Yeah, that's right.
Yeah, I don't want ghosts.
Yeah, I know, right? Kind of pesky. Then you have to call in the, what do they call them? Not exterminators.
Ghostbusters.
The Ghostbusters. Yeah, the people that do all of the
we actually have a house here in town that's used to be one of the solicitors, the original solicitors here in Bundaberg. His old house got shifted out of town, and everybody knows it as Jack's house and Jack's cupboard because the cupboard above the fridge opens at a certain time of night every night during winter, obviously because of the cold. And it's very hard to sell because everybody knows that Jack comes and has a scotch at the same time every night in winter.
Oh my gosh. That's creepy.
It is an old timber house, so of course as the timber contracts, the doors can open.
Yeah. There may well be a scientific explanation for it.
Could be.
I kind of like the supernatural though. I used to watch Britain's Most Haunted. Okay, peeps.
Thank you very much.
You're very welcome. Hello, Tam's little one. How are you? What, Tam, what's your name?
Is that
Naya.
Shania?
Naya?
Naya. Hello, Naya.
Hello.
Hello, it's very nice to meet you.
Yeah.
Yeah, and who else do we have?
Asha.
Asha and the kids, Declan, Caleb, and Riley.
Wow, everyone's here. The gang's all here.
Yeah.
Hello. Are these all Ray family people?
I've kept my maiden name.
What's your maiden name?
My maiden name is Ray, yeah.
And so the kids are?
Burton.
Burton. Okay. I'm same with me. I've kept my maiden name as well.
That's a Burton.
You're a dag.
Oh, well, it's nice to meet you ladies. I'm finished with Mum now. She's off the hook.
Oh, good.
She can go and have some dinner now and she can play.
Yay. Thank you for tonight.
You're welcome, Tam. I'll get that IRAC feedback to you shortly.
Oh, I haven't given you the analysis yet anyway.
Oh, okay. No worries.
I'll do that. I've already written it, I just haven't given it to you.
Okay, no worries.
Thanks.
Bye.
Bye.
Now, stop share.